maybe testimony and things of that nature. But, that's the thing is I think for her side right now, they're going to argue that they don't see it as so clear cut and that there still needs to be evidence to be had. And then ultimately, too, I learned from a professor in law school that all stages of litigation are really tools of settlement. And so, if she does lose this motion to dismiss, well, obviously, then the case would proceed into discovery, and both sides have the right to discovery. And so the Macrons can gather information related to the financial gains had from this, her communications with others involving this. And so depends. Sometimes you can't get tax information through privacy laws. It has to be sufficiently relevant. But it could, depending on the circumstance. So that's what, I would think is just both sides are trying to gather evidence and prove their claims. And I don't think Candace Owens wants to see discovery in this because that's going to be really somewhat invasive. And who wants to start going through their text messages and emails to try to collect all the communications they've had involving Bridget Macron? And maybe there's a lot of them. And, who's to know what they say, such as, they could say anything.
Right. Exactly. I have a question up here from Care Bears. Shout out to you. Thank you for the $4.99 super. What do you think damages are worth? Over 50 mil?
Oh, that's a good question. Generally when we're dealing with defamation, you got to prove financial losses or potential financial losses and stuff. So if you guys recall, there was the Johnny Depp Amber Heard defamation trial. And Johnny Depp was awarded a $10 million judgment, if I recall, based on that. And that occurred here in California. And, so one of the things that was a challenge for his case, and it's a challenge in all defamation cases, is how do you calculate financial losses where you haven't signed contracts yet? What are the Macrons going to do? Are they saying that they've lost out on business opportunities? That's going to be difficult because they are politicians in some sense. So that may be a bit of an issue to kind of run into. Could they recover on punitive? Maybe that's going to be governed by, state. I mean, you generally for punitive damages, you have to prove malice, and that's a little bit different from the actual malice standard of defamation, even though the terms are similar. So it's very complex.
Okay. And
I was just going to ask, how about family and, Lady Luck has defamed me and it's been adverse to my own family and such like that. Can that somehow or another be calculated? How do you calculate that in? Because all of her children have,
children are being harassed and they're being bullied online. I think I read where grandchildren were also being,
even grandchildren,
grandchildren are being bullied as well. So
in a situation like that, I think that the individuals that are facing that, like bullying or harassment and things of that nature, they would have to sue themselves under the proper theories of harassment, whether those are common law theories or statutory theories. Yeah, and so I think if they're going to argue that they're personally suffering, I would say that these individuals are going to have to bring their own claims. Those claims wouldn't necessarily attach to the defamation claims brought by the Macrons. Because ultimately, you're trying to, when you bring something to court, you're trying to recover for the injuries that you've suffered, not that other people have suffered, unless it's like class or representative, which we don't have here.
Could their concerns, though, be used to help to show more context to the extent of the damage that's being done as it's extending out to her, immediate family? Could that
and now that's
in that way?
Now that's a different point in some sense, and it's a good point. So for purposes of evidence law, it's possible that, where you want to show that there's been reputational harm, let's bring, certain family members that have suffered bullying or harassment, as a result of reputational loss. And so potentially that could be used as evidence on how it's framed or, if it passes certain evidentiary standards. So I think, that could be one lane of getting that type of evidence into court, but it might be for a limited purpose of showing certain reputational loss.
Okay. And I do believe her brother will be present to testify. He's not a party to the case, but he will be testifying as a witness, I believe. So that, I think, because they have the appeal still ongoing in France with the two journalists. So
And
it's just so many celebrities of this.
And there's
the
the 10 vloggers too.
Oh, wow. Okay.
Yeah, the Macrons are suing 10. They were suing 10, basically, content creators or people commenting online for this exact same thing. It started early in November, and it's already over, and they're waiting for the final verdict to come back. But there's 10.
Okay.
Again, it's just the same thing. They were calling her a man, so on and so forth, carrying forth this rumor and whatnot, and they got sued for it. And matter of fact, Amity Roy, who was initially sued by the Macrons, she's in the case too. So,
oh wow,
they believe in suing folk. The French do believe in suing them.
And Nick, I guess it'd be a great time to ask that question. Do you think that the Macrons should have sued Candace Owens in the first place?
No, it's a good question. I think it really comes down to how each party feels about their own case and circumstance. What do the Macrons feel they have to lose in a situation like this if they don't check Candace Owens, for conduct or statements they don't like? Do they feel like they're doing this on behalf of other plaintiffs? I'm not so sure that's the case, but is there a consideration like that? So I think it just comes down to what does each party want to recover? But generally, if you suffer reputational losses, like somebody accuses you of criminal conduct, also too, professional malpractice. So if you accuse another of, you stole from your business or something like that, that could be presumptively harmful to a person's reputation, and we could calculate damages from there. Now, I guess it's something that kind of crossed my mind just now is, there's defamation per se, and defamation per se is where you say certain statements that are presumptively harmful to a person's reputation. You do not have to prove any specific financial loss. You can just say, they said this, I'm not proving financial loss, it's harmful. Now, there's a couple categories for defamation per se, and they vary on the different states, but it generally comes down to, being accused of serious criminal misconduct, professional, non-compliance or professional misconduct, historically unchastity of a woman, interestingly enough, but I've not heard, accusing someone of being another gender. So that's I don't know if it's going to cleanly fall under defamation per se. And so I don't know if they're going to be presumptively entitled to reputational harm. They may actually have to prove specific financial loss, the Macrons. And so that's where I was questioning earlier. Well, what will they show for that? It's not so clear to me at this point. But they'll gather that information in discovery. Candace Owens can ask an interrogatory and state all facts in support of your claim of financial loss, for an example, and then we could learn.
Right.
So so let's jump to Alex Jones. What was the loss besides? Alex Jones was sued for $1 billion. That was crazy. But how did they calculate that then?
Was that primarily on emotional distress? With that Alex Jones
emotionally
loss?
distressed.
Yeah, that's an interesting question. Was it defamation or was it intentional infliction of emotional distress? As I discussed with you, I haven't reviewed the facts prior, so I'd have to kind of catch myself up on that. But it's an interesting point, because if it's intentional infliction of emotional distress on the parents, for example, then that's why maybe the jury could have said, we found that to be an acceptable theory to hold accountable him. And then when they're imposing damages, they would be entitled to impose punitive damages because it's a tort. And if it involves malicious activity. And so then that's when maybe they could impose something like $1 billion just to send a message. Now that's just me kind of like coming up with a theory right now. I'd have to run that theory through what occurred in that case.
Yeah.
I'm trying to look it up real quick, but go ahead with the question about the camera.
The camera, yes. From Wyoming Gal, shout out to my mods. Can any of this be done in camera with court? Like, can the media be allowed? I know that this can be open to the public, but can media be allowed in this particular court hearing to live stream?
Yeah, so two things. I would say it can definitely be live streamed if it's approved by the judge. And, and I'm sure like maybe Candace Owens' side would oppose that. But, we don't know exactly what they would want to do because maybe they have an interest in having something like this on, on media. And then with respect to in camera, I know that like historically that means like in chambers. It's an old Latin expression. And so if that's what the commenter meant in the in camera, like, in the chambers of the judge, resolve it. Not necessarily, like that's why we see these public filings. Obviously, each side's filed a or there's been a complaint filed. There's been an answer or motion to dismiss, excuse me, filed by Candace Owens and an opposition. So none of that is in camera. They're obviously the judge is going to consider that. He's got to read the papers and then draft an order to that effect. That's not necessarily in camera. In camera just means like the party's attorneys are meeting with the judge in chambers to kind of resolve stuff, and that doesn't generally occur in civil litigation.
Okay,
gotcha. Can I real quick say what Alex Jones was sued for? Now again, I went to my legal. I'm a pre-K law student, Nick. That means I know nothing. So I went to ChatGPT and just asked what was he sued for and what was he found guilty for. Okay, so real quick, Alex Jones, the family sued for defamation, intentional infliction of emotional distress, and civil conspiracy in some claims. What was he found guilty? He was found liable by default for defamation in both states because he repeatedly refused to comply with the court orders, failed to turn over evidence, and was obstructed in discovery. And then what the court concluded that Jones' statements were false. He knew he knew or should have known they were false. His actions caused severe emotional harm, and his platform amplified harassment and threats against the families. Damages.
Wow.
Texas, about $49 million, later reduced by the state cap. Connecticut, about $1.4 billion, including punitive damages. All right.
Wow.
So, there's a little bit more, but that's the summary of it. I don't know.
A lot of this seems to have come from.
Because ultimately you stated two theories. There's a defamation theory and an intentional infliction of emotional distress.
Right.
Yeah.
Now we have to decide. The jury could have said 0 for defamation, 1.4 billion for intentional infliction of emotional distress, or they could have maybe aggregated them together. So that's an interesting kind of point to bring up on how they calculated it. And then generally, just to clarify what intentional infliction of emotional distress is, that's just making, doing an outrageous act that is designed to inflict serious emotional suffering onto another, and they actually suffer that severe emotional distress. And so severe emotional distress, you have to show things like you were, generally that you had to go to see a psychiatrist or something like that, or a psychologist to help you struggle with some of your emotional feelings that as a result of this negative, impacts. So I think I just suspect, but I'm not, completely sure. I have to see that maybe the jury found that to be an outrageous act that no civilized community would tolerate, and that the parents sufficiently pleaded that legal element with the facts. And then also they had damages, which were likely punitive in this case if they got up to 1.4 billion. I doubt there's specific financial losses to show 1.4 billion. So
and I saw compensatory damages. So some of these parents had to miss work. Some of them were being harassed on their jobs, there was a loss of income for many of the parents because of that. So I'm
that
sure
could be recoverable.
And I saw there was a amount. I just posted up the comment. I dropped it. Oh, why did I do that?
Let me drop that
I
link.
saw compensatory damages were awarded. So I can imagine if these people are being harassed on their jobs and they're unable to go to work, even if to the point they were fired or terminated or felt they had to resign, you're talking about having to recover the loss of that of those wages. So,
but those are going to be so small in comparison to that punitive damages. That's going to be the real money. And then ultimately too, Alex Jones can't satisfy 1.4 billion. I don't think he's worth that much. So that's where you see litigants like that file for bankruptcy typically. And I'd have to check, did he file for bankruptcy? He might have actually after this to try to discharge that judgment.
Yep.
Wow.
And so I wanted to get to the next video that you have speaking on slap suits. So I think this is definitely and some of the information I want to say
I'm Nick Brooks.
You're speaking of now, and the questions that we're asking are gearing towards these lawsuits and its effect on free speech. If you consider a member of the press of any sort, which is Candace considers herself to be something. I don't consider her to be a journalist, but she claims she's a a public figure as well as an investigative journalist. Gotta help us all. So I want to get to this video, and then you can speak on that, and we can ask some questions on how much, I guess, limitation would be placed in this matter, considering the fact that she does consider herself to be a member of the press. And of course, is going to decry free speech. So you guys put a one in the chat when you can see and hear. Let's get to it.
A California civil litigation attorney. Ever been sued for something you said, wrote, or published about a public issue? You might be facing a SLAPP lawsuit, a strategic lawsuit against public participation, designed to silence you, not seek justice. Today, I'm breaking down California's anti-SLAPP law and how it protects freedom of speech by dismissing meritless lawsuits early. What is a SLAPP lawsuit? Well, a SLAPP lawsuit is not about winning at trial. It's intended to intimidate, silence, or burden people exercising freedom of speech or petition rights on public issues. Plaintiffs bring defamation, interference, or other tortious claims not to correct actual harm, but to force critics into expensive, distracting litigation. SLAPPs target media, activists, online reviewers, competitors, and whistleblowers. California's anti-SLAPP statute is found at California Code of Civil Procedure, Section 425.16. It allows defendants sued for acts in furtherance of petition or freedom of speech rights connected to public issues to file a special motion to strike early in the lawsuit. The law's purpose is to encourage participation in matters of public significance and prevent chilling valid exercise of constitutional rights. Here's how the anti-SLAPP motion works. The procedure has two main steps. First, the defendant files a special motion to strike within 60 days after service of the complaint, arguing the lawsuit arises from protected speech or petitioning activity. Second, the court applies a two-step analysis. The defendant shows the lawsuit arises from protected activities. Then the burden shifts to the plaintiff to demonstrate probability of prevailing with admissible evidence. If the plaintiff cannot show probability of prevailing, the court strikes the cause of action and dismisses the targeted claims. The prevailing defendant recovers attorney's fees and costs under California Code of Civil Procedure, Section 425.16, subsection C. This ends meritless litigation early and compensates defendants for defending their constitutional rights. The anti-SLAPP law protects statements in connection with governmental proceedings, statements in public forums of matters of public interest, and any act in furtherance of petition or freedom of speech rights regarding public issues. This includes public testimony, editorials, town hall comments, organizing campaigns, and online reviews on matters of legitimate public interest. Here are some common situations where anti-SLAPP applies. First, defamation suits against journalists, bloggers, or reviewers after negative but truthful comments. Lawsuits targeting individuals speaking at government meetings or during litigation. Claims against businesses reporting violations to regulators. Retaliatory actions against community members organizing boycotts or protests on public issues. These are all prime anti-SLAPP candidates. The anti-SLAPP law helps defendants avoid the time and cost of full trial on claims attacking freedom of speech rights. It requires plaintiffs to present solid evidence early, discouraging frivolous suits. But not all cases qualify. If conduct is not protected, the motion is denied and the case moves forward. Misusing the motion could delay proceedings or increase costs. Several exceptions exist. Lawsuits involving purely private disputes with no clear public issue, criminal conduct outside legitimate petitioning, or certain commercial speech may not qualify. California Code of Civil Procedure, Section 425.17, contains statutory exceptions, including carve-outs for certain public interest claims where government enforcement is involved. The law is broad, but not unlimited. Act quickly. Anti-SLAPP motions have strict 60-day filing deadlines. Gather evidence, save all communications, publications, or records showing that your statements were on matters of public interest. Work with an attorney like myself because the law is complex and the stakes are high. Professional guidance is critical for asserting or defending against an anti-SLAPP motion. For more information about this legal issue, please visit my blog at nickbrooksesque.com. That's nickbrooksesq.com. And also, please subscribe to my YouTube channel for more California litigation tips.
You ready?
Question. I'm sorry.
Okay.
Yes. Okay. So let me put you guys up.
There we go.
All right. So let's say that the defense wants to go around to this. Oh, Your Honor, this seems to be a slap suit if they don't get the motion to dismiss denied. What are the chances of them being able to successfully argue that?
Yeah, so this is a good question. So this is going on in Delaware State Court. Obviously, the video we just saw concerns California State Court,
Right.
and so and it could also be involved in a California like federal court too. But yeah, it's generally California law. But a lot of these principles are in different states, exist in different states. At this time, it's possible. I haven't, been able to kind of like see if there's an anti-slap theory, with what Candace Owens is bringing, but I'm not sure there exactly is, but it might be. But generally, ultimately a defendant has to identify, has what the plaintiff brought. Does it involve like a matter of public concern or petitioning activity? So just to kind of clear up like a matter of public concern, it was like some of the things I mentioned, like it's possible. Yeah. I mean, if Candace Owens brought an anti-slap motion, I think it's a good way to try to get it resolved. But again, it's not going to be conclusive. And I'd have to kind of do a little bit of digging on maybe some of like what's going to occur with respect to like, is this a public issue versus does it still cross into defamation? Because I do think the Macrones could still prevail on their claim. That's always possible. And so if they're able to show that there is a possibility that they can prevail, generally under anti-slap litigation, their suit can continue. It will not be dismissed. And so that's kind of where I'm thinking if that's going to be a matter of public concern is, I still think the Macrones could probably win out on a motion like that and just say that they still have a likely chance to prevail and they can show evidence. That's where you're going to take in an evidentiary hearing and they may have to submit a lot of evidence early. I'm kind of like going through some of the procedural aspects, and then just petitioning activity is just like, you can't sue a person for reporting you to like a governmental agency for like, let's say employment discrimination or something like that. And say that it was defamatory to report me for employment discrimination or sexual misconduct. Like, for example, if you saw the Justin Baldoni case involving Blake Lively, he actually, Blake Lively brought an anti-slap lawsuit against his lawsuit, which said it was defamation to file in the California Civil Rights Department that I was involved in sexual misconduct towards you, and that was defamation on my character. The courts found that was protected judicial activity because, submitting that complaint to that agency is a part of bringing a civil complaint. And so they actually said that's privileged, and his suit was dismissed, and Blake Lively recovered her attorney's fees. And Blake Lively, that was a good job on her part to her attorneys to recognize that as petitioning activity.
Interesting.
Okay. All right, Jason, you got.
Yeah, there's a good question by MT right there. Says Nick, could Candace Owens face legal action for throwing out?
Oh, let me pull that up.
Erica Shapiro and her ex, who is at Daily Wire employee, might be involved. Like, and I would only add to that, like, just some of the baseless, egregious claims that she's thrown out there.
Exactly.
Like, just like, hey, only people who wear, that light purplish sport coat are criminals. Like just the craziest stuff she throws out there. Can that stuff come back to bite her? And of course, MT's question as well.
Yeah. So ultimately, we're going to have to evaluate, is it a false statement of fact or an opinion? And so that's always going to be like one of the most crucial first things to decide. So I'm not exactly sure of the exact statements.
Well, she said this last night, so you'd have to really be dialed in to hear it. She said it last night, but just even in the whole thing, like TPUSA was involved in it, like in the deletion of Charlie Kirk. Like, wait, what?
Yeah.
Or insinuating the Macrones, to assassinate her. Like those types of, just inflammatory. It's so defamatory. To accuse someone of having committed a crime against you with no evidence. But I think what they're asking here is similar to that, like saying that they are part of this conspiracy regarding Charlie Kirk's murder. And
Yeah,
so
I think
saying they're involved in it.
it's going to come down to just like how concrete and like would a jury feel it's concrete a statement of fact. Because like imagine I made a statement to you, you said x person murdered y, and I'm like, yeah, sure he did, and I winked my eye, or he did not murder him and I winked my eye. Like that's a communication, and you could use the wink against me. It's just like, how convincing will that be that I made a concrete statement of fact? And so like I think Candace Owens is rather kind of savvy in that sense, where she does kind of try to walk some legal lines. Because, if you walk some legal lines, sometimes you can get attention for that as well. Because, whenever you're kind of involving somebody's reputation, it's going to get a lot of views. And so like, did she say a statement of fact, or is that an opinion? And a lot of what you hear comes down to like, as soon as like one side says, oh, well, that's a clear statement of fact, the other says, no, that was a question, or that's an opinion, or that, and so there's a lot of defenses that get brought up. So I think there's been a lot of statements. You would just have to evaluate each particular statement. And then, ultimately you'd have to select the ones you want to submit to a jury. And would the jury find that to be a concrete statement of fact? That's a question of fact, I would say to me. You would submit to the jury, is a wink from me to you actually concrete enough to hold me liable? So ultimately questions of facts for the jury. And so it's always difficult to predict the jury, right?
Right. Exactly. I do have a great question here, and I've covered this information myself regarding the HIPAA violation. Well, there's a medical staff hospital employee where Charlie Kirk was admitted that sent a screenshot of the EMR where you can clearly see identifiable information of the patient, and emailed it to Candace, which was the hospital staff committed a HIPAA violation because they're a covered entity. But Candace disseminated that information on her channel and posted up that screenshot of the EMR. You can see you can see Charlie Kirk's name, his date of birth, the department type. I mean, specific identifiable information. No one walked away confused about what patient she was referring to. You can see the information from this electronic medical record screenshot. Yeah. So the question is, do you believe that she could be held legally liable for that? And I cover CMIA as well. And I personally said that if Erica Kirk wanted to sue, she could, according to CMIA, be held liable for, invasion of privacy. But what are your thoughts on that? Just, anything you can provide on that.
Yeah. So, I mean, really, maybe there's two entities which could be held liable for, dissemination of private medical information, of Charlie Kirk. Obviously he's passed away at this point. So sometimes like your legal rights change on whether you're alive or whether you're passed. For example, Charlie Kirk would not be able to sue for defamation because Charlie Kirk's passed at this point, and generally only alive people can sue for defamation. But going back to your question, can you ask that one more time?
I'm asking basically what
could
she be legally liable for the information that she shared. That, I mean, she would need, the next of kin would be Erica Kirk. So she would need consent from Erica Kirk to be able to post something like that. So could she be held legally liable? Could, Erica Kirk sue her?
With respect to the HIPAA violation, that's an interesting question. I know I've had to send out, I've had to get HIPAA authorizations from clients before I, their medical providers will send me information. They want to see that I've gotten the proper authorization. I don't really know. I'd have to look on, do some research, right now. Cause like, again, Charlie's kind of passed at this point. I don't know. I've always dealt with alive people with respect to HIPAA. So when we're dealing with a past person, I just have to see. I mean, it's likely, yes, that, you can't public private medical information of individuals. And there are statutes out there which provide you can be held accountable for doing that. It's just a matter of identifying those statutes. Is it HIPAA? Is it another statute? And then if it's not a statute, I'm sure maybe there's some common law theories. I generally publication of private facts. That's still, you got to be alive to bring that. So I just have to do some more research, honestly, on a question like that. But it's interesting.
I did cover some information regarding CMIA. And that's kind of an act where you either received information illegally, meaning there was a violation of the HIPAA privacy law,
right,
where you received it and then you disseminated it without consent. That could, hold you liable for disseminating that without consent based on the way you received the information. So the hospital staff did not have consent at all. They did a screenshot. So the hospital staff is a covered entity under HIPAA. They sent this to Candace Owens. They emailed it to her, however they sent it to her. And it was also another
Tip
email.
line.
It's an internal email between the nursing staff that was somehow screenshot and leaked out. So now you have internal, communications being sent out, a screenshot of this EMR being sent out where the patient is clearly identifiable. And they did not get consent from the hospital. They didn't get consent from Erica Kirk. But Candace took that information and then disseminated it. And she didn't get consent. And the way she received it was through this HIPAA violation from the covered entity. So CMIA says, the way you receive the information matters. If you acquired it illegally, that could make you liable, not necessarily for HIPAA violation, but make you liable for just the invasion of the privacy and for failing to get consent. So I don't know if you're familiar with CMIA.
I don't know the acronym exactly. No, you're referencing.
You know what? Let me pull it up too.
But yeah, generally, you got to protect private medical information, and you can't let that get out. So it's like, for me, I just have this instinct that there's some statute out there that's gonna, be able to hold accountable the people that disclose that information. And then, obviously it'll be at the hospital level maybe. And then with respect to like Candace Owens, it's possible, I'd have to check some of the statutes and things involved and what her protections would be. Maybe there's a case out there that doesn't protect it or one that does. So yeah, it'd be some legal research I would have to engage in.
Ironically, it is the California.
Cali.
The California. Hold on. It's for California Confidentiality of Medical Information Act. So CMIA is specific to the state of California, but I have to see if there is something similar for the state of Utah, because it came from that hospital in Utah.
Yeah, I mean, if I guess the hospital's in California.
It's in Utah, so I have to look up if there's any state specific regulation in Utah. That would be similar to what the CMIA is, but even just the aspect of taking this, medical information here, it's an EMR screenshot and the internal email from the nurses, and she shares this on her channel, but she never got consent at all, nor did she even ask, well, who sent this to me? Did you get consent before you sent this to me? From the hospital staff. She stated it was a hospital worker that sent her that. So I highly doubt she asked, did they get consent? And of course, she shares it on her channel. And it's nothing that we needed to know. I mean, it didn't help towards anything. It wasn't proving a point. All it did was, okay, well, he went to this hospital. We know he went to the hospital.
Right.
You don't have to show an EMR to show that he went to the ER. Right. Yeah, it's like we did not need to know that information, but you can clearly see, specific information that EMR that also is specific to that system that they use. And it's just like this show nothing. It doesn't tell us who the killer is. It doesn't speak to any of that. So I guess if Erica Kirk wanted to sue and she's saying, okay, well, you guys invaded my husband's privacy. Didn't get consent. I guess what would be the likelihood of something successful, a lawsuit being successful in that situation?
Yeah, so I suppose they probably have to bring it in Utah State Court if it involves a Utah, hospital and things of that nature.
It does.
And you'd have to bring it under the proper Utah statute, which would probably be one that protects against dissemination of private medical information like we have here. But again, I don't practice Utah law, so I'm not exactly sure what statute that would be, or, I don't want to imply that, but Yeah, that's kind of how I'd evaluate it. And then with respect to Candace Owens, liability for the same dissemination, it's tough. I haven't really thought about that and how it would work out if she could be held liable, because there have been times when I guess like you remember the Pentagon Papers leak. I don't know why that just comes to me, but the reporters leaked the Pentagon Papers that came. It's like, well, then you hold the disseminators of the Pentagon Papers liable. I mean, it's not private medical information, but it's still privileged protected information, and you really want to hold accountable more so, I suppose, the source of the information which disclosed it, such as the Pentagon or the hospital or something like that. So because that's where I think the most liability is probably going to lie. That's just my instincts.
And just for the comment here, it was Charlie Kirk. His name and date of birth was actually shown. He didn't go in under an alias, so you could actually see his full name and his date of birth, which is public information since he was a public figure. And of course, it was the type of admission. I mean, just information related to the hospital. And it's like, why is she showing this? Go ahead.
Let me ask another question then. Let's just pretend that Candace redacted everything. So she didn't, let's say she showed that information and it was redacted. So Candace wasn't showing it recklessly. However, the file that was sent from the nurse wasn't redacted. So you are putting out somebody's, I got Nick's information. I send it to Lady Luck Club. Lady Luck Club redacts it. She's responsible with it. But Nick's information was still sent by somebody to somebody without proper permission. I'm just wondering, is that still a problem? Does that make sense?
Yeah, it makes sense. Obviously, if you redact it, there's a little bit more protections probably that she could argue, like, oh, I took steps to prevent certain information from being disclosed that would be otherwise identifiable. Again, I kind of go back to I think you have to hold accountable more so the sources which disclosed it and were
that's what I think,
held
the hospital staff.
Yeah, because then it's like if the third parties get it and then they disclose it, what is their liability? I'm not sure. I'd have to actually look that up. I didn't really prep for that one, so it's really kind of difficult for me to answer that one.
Well, when you come over to the J-Wit podcast, Nick, I'm going to give you time and let you know we want you to be ready for that one. There was another good question, though.
And if you guys have any questions in the chat, make sure you just put a Q in front of it so that it stands out. That way we can get your questions up.
Yeah, I've heard that before.
But so I want to make sure that I got all the questions I had in my mind. Any more questions you want to ask J-Wit while I'm thinking?
No, just real quick, just in case people just hopped in. Nick, could you just give us your resume? Who are you? And the bet is that I said you're Southern, and somebody, I think you might have already told them already. So anyway, I don't know much about you. I figured you're Southerner. Some people are saying you're from Tennessee. Well, I just want to hear all that. So go ahead.
I definitely. I said it at the beginning, but I'm from Tennessee.
Right.
Are you from Tennessee as well, J-Wit?
No, sir. I'm here in Georgia.
Okay, I thought someone of the commenters said you were from Tennessee, so I wanted to follow up on that.
Oh no.
Okay. I was born and raised in Tennessee, in Columbia, Tennessee. It's about an hour south of Nashville. I went to school undergrad university, Tennessee Tech, and about an hour east of Nashville. And then I went to Rutgers Law School. I finished there in 21, so not many years ago. And then we had the COVID pandemic when I was in law school, so we had to vacate campus. I really didn't want to move back to New Jersey because of the cold, after I had to leave. So I decided to kind of start my practice in California because I had some friends here, and I love sports, and I always thought maybe I'll be like a sports attorney, sports lawyer. Okay. I really didn't know what all that meant. But I finally kind of passed the bar. I've been doing primarily civil litigation since I've started. So a lot of civil litigation just involves the bringing and defending against different civil claims. So a lot of my job comes down to identifying what are actual reasonable causes of action that you can recover on. What are the elements of those causes of action? What facts do you need to prove those different legal elements? And then if you're on the other side, what are the proper defenses to bring? What are the elements you have to show? And all, you got to gather evidence to demonstrate the facts and things of that nature. And then, within different, the civil procedural aspect, a lot of what I deal with is more pretrial. So a lot of it's just discovery, motion pleadings, doing a lot of appearances at hearings and things of that nature.
For sure.
And I've done some, appeals work too. So a lot of legal research and writing in that aspect.
Well, cool. Well, I'm glad to have you. So what got you interested in coming out here on these YouTube streets to talk about whatever it is that you are discussing, which, by the way, I do think you do a great job. What made you want to do that?
Yeah, no, I appreciate the question on that. So really, I started kind of doing like owning my own practice and kind of being a solo. So a lot of it's, me contracting with other attorneys, like in the Southern California area, get some work for myself, but also, when you're an independent contractor, you get to operate independently. So I get to take time for myself and like, how do I get a little bit of like some exposure online and stuff like that? And obviously, you're always looking for some type of niche and stuff, right? And so a lot of it, I thought it's like legal analysis. And, when it comes to like starting the whole like Candace Owens stuff, I really didn't even know that it would kind of blow up. I just did like, some random kind of legal videos. And then suddenly I did Candace Owens and I got like 21,000, 30,000 views in a short amount of time. And I was like, wow, that's a lot. And then I did another video on the Bridget Macron case. And that one blew up to like 30,000 views in like 5 hours. And I was just like, that's nuts. And so like, there was definitely a strong demand, I thought, for like people wanting to understand like what's going on with Candace Owens' legal affairs. And it's even to the extent that like, I try to do other celebrity legal affairs and analyze them, but a lot of people don't have the same demand and appetite for that. Like Candace Owens commands a lot of eyeballs and people really want to know some of the things she's saying, because a lot of people do find them, whether it's morally objectionable or potentially legally wrongful, they want to know like more aspects about that. So, it's just a combination for me of trying to blend like what insight I can provide, maybe, get some exposure for myself, whether it's defamation law, First Amendment law, those cases can be good. I would know how to litigate them. So maybe somebody out there one day kind of sees me speaking on, different issues. And so that's kind of how I got into YouTube, was just how do I get my brand out there, establish myself, and see what kind of happens from there.
Absolutely.
I like it.
I have a question from No Reply. Shout out to you. Thank you guys for tuning in. If you guys can, make sure you're hitting the like button in the yellow C, as well as on my brother Jay Witt podcast, and continue to ask these great questions. And you guys make sure you check out Nick Brooks. Let's get his channel growing. Let's get him some more exposure, because his insight is valuable to all of us. So No Reply is asking, what are the implications of me submitting all of the lawyers' addresses, defamation information to Claire and Locke, as well as security report to RLF? That is her attorney, Candace's attorneys. Candace LLC is familiar with it. What are the implications?
Who's Claire and Locke?
Claire and Locke is
the Macron's
the
lawyer.
Macron's attorney. The attorneys for the petition.
They were also the attorneys that sued for what was the voting machine? I can't remember.
Oh yeah,
the fraud.
What was the election machine? I
forget.
It'll pop up in the chat. It'll pop up. Somebody remembers the name of it. Election machines are us. I don't know. Whatever the machine was, they're the ones that sue for that.
Yeah, they got a big judge.
Dominion. There we go. Dominion. I knew it was coming.
Yeah. They got 776 million or something like that out of that judgment.
That's a little bit. You could do something with that.
Yeah, that's what led to the termination of Tucker Carlson from Fox News. When you break down the correlation of events.
Oh wow!
Really?
So,
okay, yeah, good catch.
And let's see here. What's your question? Answer? No reply. Let us know if.
What are the implications of me
submitting all of the lawyers' addresses?
I don't know the security port, but the question means.
Are you referring to because Candace put out her attorneys, even though it's in the filing, but most people on average don't read stuff. So the address of where the attorneys work, she put it out. And there are dozens of people that work in that building, and probably would not want random strangers coming up to them.
Hey, I went there. I went to the building. Leave me alone.
Well,
I'll say random stranger.
Yeah, it's public information. Like you can, you can look up, for example, even my own, bar information and stuff. So it's like, she can always have that defense that, hey, it's already public, it's out there. All I'm doing is sharing public information.
Okay. And Sarah Kelly is asking, are there any YouTube rules or anything being broken by CO? I mean, YouTube is so finicky, but maybe I can ask this. Why is it that, if you say something that is,
I got,
because you're on YouTube now, you're a content creator, so you say something or do something that the YouTube people deem to be, inappropriate, or especially if you're monetized, they'll restrict monetization in a minute. Why is it that she gets to freely make several false statements that a couple of them I literally have debunked with basic information, and still have her videos? She still has a channel. I mean, why hasn't YouTube taken down any of her content?
It's an interesting question. I would say my best analysis on it is that a lot of the issues are very politically sensitive, that have a lot of followers on each side. And when you're dealing with a commentator like Candace Owens, she's quasi very political in that sense. So you have to consider that. And so if you ban her for her certain speech, a lot of people will take that as, well, you're trying to suppress political opinion. And YouTube's been accused of those accusations in the past. And I'm sure they want to distance themselves from like picking sides on the political spectrum, because for businesses, I don't think it does very good to overtly look too political. They're always trying to at least strike it down the middle best they can in order to increase profits, I suppose, from each side. And so, but I'll concede this point that, like, I've had one person in my comments say that, like, they feel like some of the content she dives into, especially with Israel, can border, on anti-Semitic, conduct and, statements. And it's an interesting thought, because, like, if you say, something, about another group, you could be banned, and then she's saying this, and, she's not getting banned. And so I just think it's really, it's a case by case basis. It's difficult when you're a big business to try to navigate, impose restrictions on every single user. And the bigger that user gets, obviously, I think if you just ban them, it might not eliminate their following. Those followers may just migrate to another business platform that allows that. And so YouTube has a interest in retaining the business, because monetization is a business model, and you want to empower the creators even where they're controversial. But obviously you don't want to violate terms of service, because you give ground to YouTube. And it's likely too that maybe she has violated certain terms of service, under certain arguments people could make. But ultimately, YouTube has the right to control who gets the platform and who doesn't, and where those violations occur. And just because they're unequal, they're not a public entity. They can somewhat be a little unequal in how they regulate that. So it's a little bit arbitrary, I would say, at times, but it's just the reality of trying to keep eyeballs, I suppose, and do the right thing.
So there are content creators who, there's a content creator, female content creator, who is making her whole brand to be extremely bombastic and derogatory toward Black people. Very, very egregious. Even any benefit that could have come from what her critiques were lost very quickly with her use of the N-word and just being so out of control. YouTube took her monetization away. And
I saw that story. Yeah,
Lily Gaddis knew that was coming. I think the argument can be made that Candace has done maybe not as egregious, but Lily Gaddis was already way over her coverage when she started. She already knew what was going to happen. So I think that I think the argument could be made, but I don't want Candace to lose her monetization. I don't want YouTube to do that. I want the right thing to be that the people recognize that she's feeding them tripe and them stop supporting it. But I don't want YouTube to step in, because I do think they will, put themselves in a trick bag where they look like the bad guy, and it actually looks better for her than it would if YouTube just let her rot on the vine. But that's just my little observation.
It's kind of like, to me, like, I don't know if you're football fans, but when you're watching a referee try to make a call, if the ref does insert himself, inevitably they're kind of blamed for it when you just let them play and just see who goes out there and wins it, right? Like, for sure. I think there's good side, ultimately, if the litigation doesn't turn out how Candace Owens want, right now we may not be talking in negative circumstances about that, but it could turn, more, you could take shots at it and say, well, you didn't win that motion to dismiss, and you could maybe take a little bit more shots that way. But yeah, with respect to some of the I've definitely seen it. Some of the whole racial or ethnic and national origin or religious kind of discrimination from different, pundits. It's very unfortunate. I don't think really the platform should serve that. And, public entities can't do that. Like if you're a government agency and you try to engage in that, you should be held accountable by, either the feds or somebody should step in for that. When you're a private platform, they have their terms of service and they can govern it. And then sometimes it's tough to make calls on, what's contemporary a little bit more. Like, for example, I'm not sure you saw the Puka Nakua rubbing his hands together on that podcast. And then that got a little bit of traction online. That's a little bit more contemporary. I think, what's his name? The white Nick Fuentes was doing that on his podcast, rubbing his hands together to really imply that the Jews are not good people and stuff. And that's what they do. And that's wrong. And so that's kind of contemporary anti-Semitic slurs that are arising as we just see them develop on YouTube. And now suddenly, sometimes they can be mainstream at that, and amplify. So I think social conduct can change quick. So law has to change quick too, to identify what is discriminatory and why is it discriminatory. And how if you say certain slurs, does this slur rise to the level of this slur? And it's difficult.
Right. I have a question just on the Macron case. So the Macrons, of course, live overseas. Do you think that this should have been a matter they filed in their court, even though I do believe that they're standing for them to come here? But
in France?
This is a question that's being asked here. The actual question here is, what's protocol on overseas litigation? But I mean, I don't think would you know anything about that?
Yeah. So when it comes to, we have to identify the proper venue essentially. And so would venue occur in France or would venue occur somewhere in the United States? Well, when we're evaluating venue, typically, especially at the federal level, you want to identify where did the acts or the transactions occur? And here the acts were statements made. They occurred in the United States. They didn't occur in France. And they might have made their way over to France eventually, but those statements occurred in the United States. And when you look at the lawsuit, the business entities of Candace Owens are named, and those business entities are registered in Delaware. And when you register with the state, you accept service process when somebody brings a lawsuit against you. And so essentially you're stating the venue's proper here where somebody sues me. So that's why the Macrons chose a Delaware state court, because her businesses have, established themselves as this is a proper state to litigate litigation that comes up against this business, which has occurred here. And so I see some commentary about, her trying to change the venue to Tennessee at times. The only issue is you can't really do that because we're talking about state level courts. Delaware can't, Delaware state court can't transfer a court to Tennessee state court. The Delaware state court would actually have to just dismiss the case and then let it be refiled in Tennessee. But that's not going to happen because venue is proper in Delaware. And so, if she brought a motion to dismiss based on venue, I think Macron's attorneys would argue, no, your business is properly submitted, that they would be, amenable to litigation in this state.
Believe it or not, that is what the motion to dismiss is. It's based on libel tourism and it claiming lack of jurisdiction.
Yeah, there's three parts of it. And one of those is that you're right. Does it matter at all, Nick? Let's just say that it was all things are equal. And it really was an argument about whether or not the case should have been brought to Delaware. Does it matter at all that Candace has sued entities from Delaware?
Right.
She sued USA Today from Delaware.
In Delaware.
Does that matter? Would that actually be like the straw that breaks the camel's back, so to speak?
So basically, to use her previous lawsuits, bringing Delaware companies, as her understanding the law and how that works.
That is correct.
Yeah. I don't. Here's the deal. I think if you brought that, sure, you can bring it, but ultimately, I don't even think you have to consider that for purposes of just declaring this is the proper court. Here's the proper court because your business is registered here. I would stop the analysis there. I wouldn't go to any prior, litigation she brought. I think it could maybe, like we talked about, risk confusing issues. I think a judge would see through it, but ultimately I don't really think it adds to the legal analysis. I would just say venue's proper because your business is registered here.
Right. And she confirmed that in a video that her LLCs are registered in Delaware. So she destroyed her own defense with that.
She talks too much.
Oh, it was epic. She said, yeah, I have LLCs that are registered in Delaware. I was like, okay, well, there's your defense. Destroyed, lady. Like, you can't say, oh, it should be dismissed because the defamation occurred in Tennessee. Well, it's not because just that. It's because your LLCs are registered in Delaware. So
and ultimately the Macrons could have chosen, did they want to bring it in Tennessee or did they want to bring it in Delaware? And so they chose Delaware, and chose
Delaware.
Yeah, a lot of your major corporations in the United States are registered in Delaware. And so, and because they have really sophisticated court systems that know how to address certain corporate law issues. I mean, defamation is what we're dealing with here. So it's not exactly that. Right. But, I think, forum selection for the Macrons, and they chose Delaware as the suit. I've seen some comments on my page about, there being a high French influence in Delaware. And I just kind of laugh at that because, Delaware was the very first state.
Yeah.
Yeah.
And so I'm like, well, I don't know if the French are still influencing if it's been a first state and for over 200 years, but
yeah. Yep. I think people they're picking up on whatever reason to believe that this is going to be stacked against her. Because she knows she's going to fail, in my opinion. I'm sorry. Based upon my own information belief, she's going to fail. Yes. So she's already kind of framing it so people can accept the loss. And say, oh, see, we knew Nick was no good because we already knew that anybody that wears a tie on Saturday can be no good.
That's right.
So therefore, he's wearing a tie on Saturday. I knew he was no good. So anything you come up with is no good.
Yeah. Right.
Yeah. Litigants always try to find ways, like, who's to say, right, that let's say Candace Owens could move for a physical examination in the Bridget Macron case. Let's say she's denied and the judge says, the reason I'm denying this motion is because there's other sufficient evidence which proves certain issues or sufficient evidence to show you don't need this. It's too invasive and a violation of privacy rights and dignity. Who's to say Candace Owens can't just openly disagree with the judge and say that I don't like that and it's unfair. And I still think she has that, potential pathway to just, but it's like, it doesn't matter. The judge is, the one interpreting the law. She might not like it. But, and it can make her look bad to the judge if the judges are good people typically. And I don't think they're going to be, trying to look up daily what Candace Owens is saying about them, but it's probably going to get around to some little comments if they go too far.
Right.
Yeah. Don't be like Johnny Somali.
I want to ask about, the insinuation she's throwing at Kirk, TPUSA, and her meeting with Erica's meeting with Candace Owens. Mm-hmm. I guess, let me ask this. Do you think it was valuable for her to even fly out to Tennessee to have this conversation with Candace Owens, only for Candace to come back out, basically making the same insinuations and statements that Erica Kirk is involved or is connected to people that she's accusing to be involved? What was the purpose of even going out to Tennessee to have this conversation with Candace Owens? What do you think should have came out of that?
That's a good question. I think, it's kind of, I'm definitely kind of speculating to an extent on what maybe was said in that conversation. Because,
of course,
there could have been a multitude of things said. I don't know if you saw one of the Cuomo brothers. He got on his show on News Nation and said that he thinks it's all fake. And I was like, oh, that's an interesting take. Like who's just, I doubt, I don't know if I'm subscribing to that, but when it comes to like what they said, I guess I could maybe suppose that Erica Kirk kind of said how she felt about the situation, her own emotional thoughts and feelings about it. Maybe how this is reputationally harmful, whether to her, to TPUSA staff members, to the organization itself. And a lot of it probably was just imparting different facts that could later be used to establish that Candace Owens knew after this conversation where we presented X, Y, and Z evidence or, certain things that what she said thereafter was, wrongful. And I mean, that's just, maybe plotting how to set that theory. And as I understand, like, or were there attorneys there at that as well, or was it just those two? I'm not so clear.
It was Erica and the COO. And then at some point in the questions that Candace brought up, she then brought in TPUSA's attorneys on the phone. So she contacted them. And it was about the criminal matter, to which they're not a party to. They're not attorneys representing the state or the defendant. So I don't know what the TPUSA attorneys were supposed to give to Candace to make her happy with any answers. But they did call. Erica did call TPUSA attorneys over the phone to ask about, some of the evidence that Candace is demanding from, the criminal, from the murder trial, from the investigation with that. So I wish she would have brought her attorney with her, but she didn't. So
yeah,
she called her.
It's tough. There's a lot of things that could have been discussed.
Yeah. Well, I'm going to say something. I think a lot of things were discussed. If we talk, Nick, for 4.5 hours,
right,
we're talking about a lot of stuff, man. We're getting a lot of stuff. And and we got issues. So it's not just like we're just meeting each other, but we got some real bones to pick. That's a lot of time to talk, man. I think they did talk about a lot. Because if you just, and I do a live stream every day when Candace goes live. So I've listened to a lot more to Candace than probably is recommended by the FDA. So that being the case, I've heard, and like, she probably explained about 30 minutes of the conversation. Out of 4.5 hours, I'm giving you minute by minute, 15-minute blocks of everything we talked about, because I know everybody wants to hear this. She gave him maybe 30 minutes, maybe. So the reason I say that is I think they talked a lot, and I think they said a whole lot. And the reason I say that is because what has Candace said afterwards? She's talked very little about TPUSA. She was going hard in the paint about TPUSA was a bunch of mobsters and gangsters, and they'll give you cement shoes and all this kind of stuff like that. She comes back and everything's sunshine and rainbows. She talked about a whole bunch of new topics. Now, granted, she got that guy to come in and kind of implicate Erica into some crazy Fort Huachuca conspiracy, but she kind of stopped a lot on this. Right. And she stopped a lot of that. So I'm wondering if she was shown more information than she divulged. And Erica said, no, this is what we have. Now, if you keep running your mouth, we do now have proof and evidence that you have this, you've seen this, and now we can file defamation against you. Because now you know. And not only, we didn't just email it like Claire Locke did. We came and brought it to you. We got your fingerprint on it. We know you saw it. And now you that's what I think happened. I think there was a lot more information was shared than Candace would ever divulge, because she has really tampered down. She almost gone, like, she's tampered down a lot. My joke was, if she comes back talking about knitting and all that kind of stuff like that, we know that TPUSA brought a lot of evidence. If she comes back talking a little less, then we know a little less about TPUSA. We know they gave her something, some kind of offer that she couldn't refuse. So that's what I think happened. In my opinion, I don't know it emphatically.
Yeah, no, that's a good point. And my biggest concern is just like, in criminal trials, the prosecution has to prove its case beyond a reasonable doubt. And so in the prosecutorial theory, as I understand in the state of Utah, is likely going to be that, Tyler Robinson acted alone and he, was involved in the assassinations, as the allegations currently stand. And so like with that, where Candace Owens does put out these different alternative theories, does that create the sufficient amount of reasonable doubt? Could the, attorneys for Tyler Robinson look at that and say, there's a lot of people out there that believe that. We might just look at the comments section and maybe gauge a jury that way. Like, who's to say that the jurors aren't going to think similar to certain commenters, and what certain theories out there are more plausible than others that a jury would accept to sufficiently find reasonable doubt. So that's one of my concerns with that. It's an interesting one.
And also, okay, go ahead, Mike.
I was going to pivot to Tyler Robinson, but go ahead.
If you could pull up Captain Jack's, because we didn't say it emphatically. If you could pull up Captain Jack's, thank you for the $5 super. they called Erica's attorney, not the prosecutor. Erica's attorney has only the information that the prosecutor counsel or PC and charging, I'm sorry, in the PC and charging documents. So I didn't want to, I might have misspoke when we
Did
said
she
that as
say
well.
there was TPUSA's attorneys?
Yeah, she did.
Because TPUSA, okay, TPUSA attorneys, are they the same as Erica's own personal attorneys?
Generally, no.
Yeah, I was about to say, I think there would be two different sets of attorneys here.
Yes.
But neither of them would have more information about the case.
Yeah, they wouldn't have anything about the criminal matter. Not at all.
So I mean, it would be like me calling Nick. Like, Nick is my attorney. I appreciate you, but you don't know more than I do. Sadly,
neither of them would have. Yeah, no, not at all.
Yeah, and two, they probably got a lot of their information as a result of, like, they were likely investigated, by authorities in Utah to, what do they know? What did they, like, what happened leading up to all this stuff? So because I mean, the prosecution has to build their case, and they've got to make it bulletproof to avoid any type of, like, arguments from the defense related to reasonable doubt. So I'm sure they definitely learned some facts, just maybe even indirectly by being asked certain questions, like, oh, that's an interesting question. Well, let me answer that, so it's interesting.
Yeah. So the Tyler Robertson case is, I guess, it's starting to pick up in court. There was a hearing, was it last week, regarding member of the press live streaming inappropriately in the court. It was a violation of the standing order on decorum. And, this is standard order for all of the cases in court when it comes to, press release. And now you have I believe it's the prosecutors that are pushing for a restriction on that. What are your thoughts on, the prosecutors' motion? Yes, like having members of the media in the hearing, in the courtroom. Do you believe that is some sort of infringement upon free speech and free press?
No, it's a great question. And I've actually spoken with like judges on how they do it. And each judge can kind of handle their own courtroom on how they see fit. And, ultimately a judge has got a lot of power in society, and with great power, you know what I mean, comes great responsibility.
Right.
So like if you're allowing in media, the reason you generally have to allow in media is the media themselves have to make a motion to be allowed in. And so then when they make a motion, the judge will consider the different public implications. Like, maybe there's a huge public interest in a case like this. And clearly in a case like this, we have a ton of public interest. So allowing in media members to do different activities, that's fine. It's just, if the judge permits any type of media activity, like you said, there's going to be a standing order related to what's acceptable media activity. If live streaming is not a part of that order, you're effectively violating the law, actually, because, the law says don't do this, and you're kind of being granted an exception by the judge. And so if you exceed that exception, you're basically back into violating the law. So I can see why he definitely made an issue of that. I think by making an issue of that, it just kind of like, it kind of taints the decorum that, maybe Robinson's side can say, oh, this was a ridiculous type of proceeding or something. And you don't want to give grounds to that. You want to make sure that everything goes as perfectly as it can. That way, later on, he can't look back and point to anything that would give him grounds to object.
For an appeal. Yeah. They're going to hand him an appellate case if they keep doing this. They live streamed a hearing. They were not supposed to be live streaming. And I think they picked up some audio and that was of conversation that was being discussed with the attorney and Tyler, I think, or between two attorneys. It's still privileged. So it's like people don't want. Erica Kirk wants the cameras there. She wants, this to be live streamed. But if it comes down to the fact that it could end up hurting the case, especially during, any of the hearings that's going on. These are preliminary hearings. This was a hearing on a motion. So it wasn't even, getting to the actual trial itself. I mean, just preliminary hearings addressing motions, and now they had to have a motion for possible violation of that order. The risk is too great. They've been wanting to try to kick out the media since the beginning. So to do something that would make it worse, if from a member of the press, it's it's hard to say, hey, we want free speech, we want free press, but then you're going in and you're violating court orders. It's hard for the judge to want to, give Erica Kirk what she wants with that.
I would sanction them. If I were the judge, I would just sanction the media member. I would sanction them for like $1,000 to $10,000 probably for violating the standing order. And that would send a message like, deter, you're not going to do this. If anybody else does it, the sanction might go up. Because you want to appeal to both sides. You want to deter any violations of the standing order related to media, but you also want to satisfy that if the public demands, they want to see this trial because it's that important to them. That's also a huge consideration as well. So it's like, what solution do you find? And I think sanctions on the violating like media members would be sufficient because their employers are going to have to pay that. And, if you're an employer paying $10,000 for a sanction violation, you're going to have a strong talk with that employee who did it.
Yep, absolutely. And probably, you will give the court credence to have that person banned.
Yeah, because also you preserve the integrity of the trial as well. So it's like if you impose that, it's like people are like, all right, this is serious. This judge isn't just playing around and letting people violate the rules. Like, you're going to have to do things the right way, and it just gives more decorum and integrity to the proceedings.
Absolutely.
Y'all put hashtag 10K Nick in the chat. Nick is gonna charge you 10K, man.
I'm going all the way there.
I'm going all the way live, man.
I said that. I did a video on that. I said, oh my God, they need to sanction them because this is going to taint the jury. Is going to, create this biasness about the matter. You're going to give the defense, more credibility to say, well, we're not receiving due process. It could get to the most extreme point. And that would be my question as well. Do you think if it continues on that they could seek, a different venue here? It could, they can have a better argument to say, what, why don't we just transfer this to a different venue where we might be able to have, a more secured trial and hearing, and my client can be ensured due process here. What are the chances of that?
So since the crime occurred in the state of Utah, I think Utah State University or one of those universities in Utah. And so with that, you have to prosecute that in Utah. It wouldn't be appropriate to prosecute it in Nevada because the act
moves to Delaware.
No, I mean move it to a different. Move it to a different district, not necessarily in that court, but take it to another court in a different district, but still in the state of Utah. Not taking it out
possible,
of Utah.
But you would have to meet the statutory elements related to the change of venue. And I think, this, I don't know the exact Utah requirements on that. So, and I'm not a Utah attorney, but it generally, like if you're trying to change venue within a state on that, it's because you feel like you can't get a fair trial in that particular county or something like that. So let's say I had some case here in San Diego that was like a criminal case that was really a lot of people knew about it. It upset people. And I was worried about a tainted jury. I could then just file with the court. Hey, I want this done in some county way in North California, or maybe even LA or somewhere east of LA, north of LA. And that would tone down some of that prejudice. Maybe. I mean, obviously when we're dealing with something like this, Charlie Kirk was a very national public figure. So it's like, are you going to get a better jury by changing it? And maybe that's one thing the prosecution could say is, hey, it don't matter if you change it. You can change it all you want. You're still going to end up with a jury that knows about this at some level. But I'm sure, they could still find a good jury, likely where they are. And definitely if they change too.
Okay. I love it. I love it.
Yep. So
nice work.
The sanctions, what are the odds that the judge is going to actually give sanctions from this particular violation that occurred last week?
On the media members?
Yeah.
It's so I would say this, it's probably going to come down to how was the standing order worded? Is there any reason? I mean, it's likely the court's going to say to that media member, order to show cause related to why we should not impose sanctions for your violation of the order. And then that media member is going to be obligated to provide a response. And is the response a sufficient one? Can he say, hey, the language wasn't clear about this point? That could be one ground. If the judge finds that persuasive, he may just amend the standing order to make it more clear. May not change it and just impose like a very strongly worded order. Maybe it's a lower sanction than what I said. So there's a lot of options on the table, and then the likelihood of it being imposed. If this was a first time offense, I think that can definitely weigh into the situation. And so if the judge just makes it clear, like, hey, I know this happened one time, and this first guy said he didn't understand the order, he or she didn't understand it. But if this happens again, I don't care what you say, about it. I'm going to impose sanctions.
Oh yeah, absolutely. And I think that's exactly what should happen. Especially if it would be challenging to take it anywhere else, and you still have all of this information being peddled out from, these huge content creators, Candace, where it's, the information is being heard, throughout the state, and of course, picking a jury at this point is going to be so difficult. In the process to jury selection, I've kind of gone over that. It's not as straightforward as people think. So they want to be able to select the best jurors and then have their alternatives on the side.
What would you ask the potential jurors?
I mean, I would ask, of course, what there is exposure information out about this case. Is being nationally televised. Everything that's going on with it is being scrutinized. But, I would ask basic questions on their understanding of being able to evidence or anything. I have. I watched the hearing regarding.
I would ask the juror that. I would say, have you heard of this case before? Yeah.
Oh yeah. Have you heard this case? Your understanding of, the defendant. What do you understand how to gather evidence? Do you understand what the evidence has been gathered? Do you listen to, what are you listening out to social media? I mean, or what is your influence? How easily are you swayed or influenced by social media?
Yeah.
Or by certain individuals in social media? Because that kind of gets to the heart of, are you selecting a jury that can be impartial and not be influenced by the things that are being said, especially by these, high profile figures like Candace? Whether people are subscribed to her or not, people are still listening, and that is problematic. And so if there's a chance that they come in there and they might be ones where they firmly believe what she's saying, you got to ask the questions to kind of weed them out. So it would have to come down to that. That to me would be the biggest hurdle. If you're being influenced heavily by social media and certain social media presence and information that they're putting out, if you're swayed on this, it's going to make it hard for you to be able to see this, impartially. So go ahead. I'm sorry. I didn't mean to cut you off.
Yeah, no, I mean, I would probably ask, similar questions as that. In addition, probably like, this case deals with some serious facts. We have an allegations related to murder. Like, would you be able to emotionally tolerate sitting through a trial like this and be able to like come, to a verdict on that? Like, is that something you feel like you could emotionally withstand? Because I'm sure some people, once they have like these weighty allegations, who's to say, somebody in their family didn't experience like a murder of their family member or something, and like they just couldn't decide, or that it would remind them too much of something in their own past. And so like I would probably be asking some of those questions too, or like, how political are they? Do you find yourself to be a very political person? Do you know who this is? Regardless of a person's politics, could you see them as a victim of something like that, whatever speech they may have said? And so those are going to be really important questions. And like, I'm sure, a lot of people are very opinionated, but maybe you could find certain people that like, they don't follow politics so much, or like, oh, they're fine with, and so like, I would be trying to locate those, in some sense. But if I were maybe the defendant's attorneys, maybe the prosecution and defendants just have different, like who they want to go after as potential jurors too.
Right. And in both sides have the opportunity to ask questions to help determine, the jury selection. I feel like Candace, and it's just my opinion, is saying a lot of things that could end up helping the defense, especially if, there's been so much doubt cast on the investigation overall, and especially coming from someone who's not very well versed on the law or on how a crime scene is processed or evidence gathering. she's not versed on any of those aspects, but yet her ability to sit and paint these narratives, and people are going with what they're feeling, like you said, the emotion, the connection that is being swayed with that. I think would be the best way to weed them out, that emotional connection. If they have someone that they know they have they've lost in that similar fashion, you want to kind of say, okay, well, you don't want to be emotionally connected. You don't want to be, because you're being emotionally connected to things that are being said from someone that is invoking all of this doubt. So you want to be more factually based, and you want to be able to have a clear head so that you can make a decision um, that's impartial and neutral based on the finding of fact and evidence and what the law says. Um, and get down to that. I think they're gonna have a hard time, really, if she continues to go at this rate. They're gonna have a harder time trying to really weed out people um, that would not serve well on a jury. That's just my personal opinion. I think it's gonna be a little bit more difficult as time passed by. So you let me know your thoughts on that. You think that is
I'm
I
not
don't know
so
if you
sure it
listen
would
to
be
all her
that.
shows, but
Yeah, and that's the key question. I don't know how, like, if we suddenly got 16, 20 jurors sitting in front of us, random people
Mhm.
selected, like how many of them have heard of Charlie Kirk? I wouldn't say 100% have ever even heard his name. Like they might not even know
Right.
who this individual is. And so like, those would be people automatically. It's like, all right, well, they don't know. Oh, this person was really following the case. Well, strike them. They're out of here. Like, because
Mhm.
inevitably, like, yeah, if a person's too biased, it just kind of negates their own independence and they can't really consider the case independently.
Right. So let's say, they're learning about him through watching someone like Candace Owens. You know, maybe that's how they're, getting information about who he is and all those things, but they're getting it directly from that one source. So would it be appropriate to ask,
You
hey,
could ask him,
are
you could
you
say,
do you
do you
watch Candace
watch?
Owens?
Yeah, I would say, do you watch podcasts like on YouTube? And if
Right.
so, what do you watch? And like if they say something that is Candace Owens, or if somebody related to Candace Owens, like in
Right.
that ecosystem, I could then
Uh-huh.
say, oh well, strike that person, if you want to strike
Right.
them.
Oh, okay, cool. Because that would be my if I had to ask the question flat out, do any of you watch Candace Owens? And it just whoever put their hands up, you gotta go.
Yeah, yeah,
Because
that's a good way to
I
do it.
would I just would not want that on the jury, because I just don't see how anyone that's listening to her regarding this matter is remotely able to be impartial. It's just complete biased. So yeah, you gotta go. But
Yeah, and
go ahead, go ahead.
I was gonna say, a lot of attorneys, when you're at trials, like they're just
Mhm,
constantly. I mean, I was once a juror actually after I got licensed, interestingly enough, and I hadn't done a
mhm,
trial myself at that point, so I truly felt like a juror, and I'm listening to the attorneys, but I'm a trained
mhm,
attorney, so I'm like listening to them to present their points. And I just remember my own impression was every time they were up there, these attorneys were asking me, "All right, let's just hear
mhm,
all the evidence. Let's be impartial." And they're like constantly reminding you of it, to the point like it's almost like you
mhm.
hear it every day, every minute, every hour. It's like you do kind of think into
Right,
that. And
right.
then ultimately, like, it's difficult to trust any, like the jury system is like, it's what our system is. But, when you're dealing with actual human beings, inevitably people
Mhm,
are going to see them as biased. And, we've always heard, in the past of, people not believing certain juries or jurors were
mhm,
fair and they're deciding. So I think you might not ever escape those allegations. That just might be,
mhm.
you kind of take the bad with the good, I suppose, in some sense, and that's going to be one way to attack it. But what other
Right,
system do you have, I guess?
right. And this is a question from Truth. Can they check potential jurors' social media? Are they able
Yes,
to even? Okay.
but you
Oh,
cannot notify a juror that you checked it generally. So, like, how, like, if
okay.
you get on LinkedIn and you go to a
Mhm,
person's profile, it'll notify them that this person checked their profile.
okay.
Yeah,
Yes.
if it notifies that potential juror, like, Nick Brooks looked at your LinkedIn and they know that, that would actually
Oh
be
boy.
improper juror contact. I had to go to a recent legal event and they were telling us about that.
Wow. So they would be able to check their social media if it's, I mean, well, does Instagram or Twitter X, does it notify you if someone has checked out your page?
I don't believe so. I believe those
Okay.
platforms don't, but LinkedIn
Okay.
was actually the specific case I was dealing with. And when you visit a profile on LinkedIn, it'll notify that person that somebody's visited their profile. So be
Okay.
wary of that.
Okay. So that would be a good way to weed them out without necessarily having to put them on, on the forefront and asking. I mean, I would simply ask, do you listen to Candace Owens? That would probably take away a lot of that biasness, but they can also go in and check just social media. That would be a great way to also determine what they're looking at, and if they're heavy on social media, they're constantly posting, and responding or engaging in conversations. That gives you an idea of what that person, is thinking. And then, of course, that gives you an idea whether or not they will be a good fit to be a juror in this matter.
Yeah.
Susie Q, shout out to you, honey. How you doing? She's asking, can Brigitte Macron be forced to prove she is a woman through testing?
Yeah,
Did we cover that earlier?
A little bit, yeah, and just kind of a quick.
Okay.
I mean, hey, it's going to come down Delaware state procedures, and she's going to have to show good cause for any type of physical examination. And I question if good cause is going to be sufficient, but she'll have to bring a motion and show that, and the judge will order it. After the opposition too is filed.
Yeah, I just personally, I've said this previously. I don't think the judge is going to order her to get tested, but I mean, and mainly because the attorneys are going to object to that heavily. And what would be the legal premise to this? Like, even if you have court rules to say, hey, I'm claiming she's born one gender over the other, that was no intent on doing, there was no reason to even do that. It's not like you're, trying to protect the public from anything. So it was just more salaciousness to begin with. So if you say I file a motion for her to be tested, and her the Macron's attorney is like, well, why should they have to be tested on something that she theorized, and she has no evidence to prove that she was born a man to begin with? That
Or
was
she has
the reason why.
alternative discovery methods to prove her point. Like, if she gets documentation, medical evidence, for example, through documentation that shows that her claims are, false. I mean, I saw some commenters say, well, oh, medical documents are easily falsifiable. Well, you don't turn in documents to the court that are false. You'll violate the law in doing that, and potentially land in jail and lose your license and everything like that. So I don't think anybody's going to be submitting false evidence, under penalty of perjury in this case.
Right.
And so, yeah, if she moves for a physical examination or testing of some sort, and it's not really warranted after all of the other evidence available, I don't think it'd be tough to see her getting that. But there's no guarantees in law generally.
Yeah. Okay. And then of course, they have an order that was posted up on December 12th. So her attorneys, Candace's attorneys, were granted an order for a word limit and deadline for reply in support of the motion. They increased it by 7,500 words, and that is due January 6th of next year. So, I mean, they're doing this deliberately. They're trying to delay this as much as possible. What are your thoughts on that? And I can pull up the actual docket so we can see it in real time, because it's like, why did they keep stalling on this?
Yeah, no, I mean, generally, whenever you bring motions or oppositions or replies, you're required to only have a certain maximum word limit and pagination limit. So how many pages you get. And so you can motion to extend the word, or, make larger the word limit or more pages. It's just, you generally have to show good cause for why you need that. I suppose that she brought that motion, or would they stipulate to it here? Or?
Yeah, it's a stipulation.
Yeah, since they stipulated to it, she didn't even have to move for it. So the attorneys agreed, all right, go ahead and file your expanded word limit motion. So she'll file that. And I've never really needed to bring like my word limit up. You just kind of got to state
Right.
your issues more concisely. Like if you find yourself trying to expand words, it generally means you're not really getting to the issue, And so,
Right.
and maybe she wants,
So,
it could be a distraction tactic. We never know.
I think so. I think that because this is the second request for an increase in word limit, even if they're saying, well, the FAC, the First Amendment complaint, is well over 220 pages, so our response needs to be able to address, what's being stated in the amended complaints or whatever motions they're bringing forth. It's just they know they're going to need these additional words. They know that court rules won't allow so many pages of terms. Why wait to the last minute to file this? Or, they stipulated it, but, the Macron's attorney filed an answering brief on December 3rd. And it took them to the 11th to get a stipulation done where I guess they agreed to say, okay, well, maybe it's because the holidays are coming up. I don't know. It just seems like they are stalling. This is the second time they've asked for an extension or they want to increase word limit just to still say the same thing. It's like she's going out of her way to avoid this hearing. So
Yeah. I mean,
I just think it's a ploy. Yeah.
Yeah, you're generally permitted to, obviously, once you bring a motion, the other side has a right to file an opposition brief or an answering brief, as they term it here. So that's what they did. And then after the answering or opposition brief is filed, the moving party then gets to reply to that. And then generally there's no reply to the reply, although sometimes it can happen depending on the circumstance. But so when it comes to the reply, you're limited, though, to like a lot of what was stated in the opposition that you're trying to like poke holes in. So you can't just start referencing things external to the opposition or the moving papers themselves.
Okay. And I mean, it's just, this is why I'm like, why don't they just have a hearing on the motion? That way they can present their arguments and, as far as adding extra words in, what are those extra words going to even address that they can't address directly, in a response or a reply? I mean, they're trying to get the matter dismissed. So if it's being dismissed based on libel tourism, you're basically, stating your claim again, and then maybe trying to object to any further or new additional accusations being brought forth or any claims being brought forth. But if you're objected to that, then you're objected to that. But if you want to just go to court. That to me, that's my whole thing. Why not just go to court? Why not just ask the court for a hearing on the motion to have this heard, and then they can bring forth the legal arguments and do it that way? Why keep asking for additional words in writing? That's what
so whenever you bring motions, you're generally required to submit moving papers. So you do have to submit the actual written documents themselves, which set forth your theory, because that just allows the court to read what you have instead of like, because when you're dealing with somebody orally, sometimes it can be all over the place versus if you have to write it down, we can, all right, this is your position. Now we know it. And so like, each side has to submit all of the moving papers properly. And then after the moving papers are submitted, the court can generally, it has the option to have a hearing. They can, hear oral arguments from the parties in support of their moving papers. And so a lot of their oral arguments will have to be limited to what they put in their moving papers. So they can't write these things in their moving papers about A, B, and C, and then in their oral argument talk about D, E, F. They're limited to what they wrote down. And so like, but the oral arguments just to supplement and help the judge further understand anything that, he doesn't or she doesn't already understand from the moving papers or resolve any questions.
Okay. And there was a question here. All right. So in my opinion, this is from Greedy Puppy. The issue is not if Brigitte is a man or a woman. The issue is that it had a relationship, or Brigitte had a relationship with a minor and a student. So when it comes to matters of that nature, what what role is that going to play as far as, Candace trying to use this defense? Well, I didn't report on this because she was born a man. It was more so because because you can't say she's born a man, but then say she was preying on a student at 14, 15 years old, I guess, of some sort in France. That action did not occur in the US. So, I mean, what value is that to a court here in the US to say, well, we're bringing up this issue because we believe that she was, trying to, coach and engage with a student in France while they lived in France.
Yeah, I mean, with respect to the minor and the student allegations, those are serious, improper allegations, and in our own social discourse, we don't really endorse relationships like that. And so I can understand why people have moral and legal issues and objections to any type of relationship like that. But I guess the issue here is we have to focus on what are the allegations as set forth in the litigation. And that relates to defamation and Candace Owens calling Bridget Macron a man rather than a woman and alleged reputational harm. So that's also an issue. So we are dealing with two issues. It's just the litigation has to concerning one, and we do have to properly resolve that particular issue. That doesn't take away from the other issue. It's just, that other issues dealt with differently, whether it's social backlash, elections, or independent lawsuits on those issues. And so that's just how I would frame it, is I understand the inappropriate relationship and things of that for many people. It's just we have to deal with the defamation issue as well. And, you can't just use this issue to distract from this issue. And we don't want to address this issue because that issue exists. It's that's not the way litigation works.
Right. And then also, there's nothing that the U.S. court can do about that, right? If you're trying to bring that forth to say, there should be some sort of punishment or penalty, what penalty would you expect a court in the U.S. to do about a matter that occurred over 30 years ago in France, where they ended up being married? So it's like, what are we supposed to do about that in court?
Yeah, you have to generally, if you're going to be a prosecutor or you're bringing civil cases, usually where you focus on the venue, as we discussed, and where did the acts occur. Here, those alleged acts occurred in France. And so they would properly be adjudicated in France with respect to that inappropriate relationship. The reason the defamation, its venue is here in the United States, is because those alleged defamatory acts occurred within the United States. Yeah. And so that's the nuance on that front.
Yeah, absolutely. So that, to sum everything up, is a lot of this Candace Owens has done. She's initiated on her own accord. And the additional, defamatory attacks against TPUSA, implicating everyone or inferring that everyone is involved. From whole countries to, the French president to, TPUSA and individuals in TPUSA, Erica Kirk. It goes on and on and on. It's bringing forth a lot of cyber crimes, such as not cyber crimes, but cyber harassment, the bullying, the more defamation, and doxing. So I know I've spoken heavily on that. Doxing is illegal. It's illegal. When she puts up people's photos demanding to know who they are or to get information, I can say she's liable for that. But what are your thoughts on that? If they decided to pursue lawsuits? Yeah, hey, you put my photo up on your channel, and it's the guy in a green hoodie, and now this kid is getting, backlash and retaliation. Or all the kids that she's posted up photos of that, because they were wearing maroon shirts, now they're being subjected to, this campaign of harassment and bullying and defamation. What are the chances that they're going to go and try to pursue something in court against her on that?
Yeah, it's a good question. I'm not sure. I think they'd have to evaluate, do they, want to pay an attorney's fee to pursue something related to harassment? Do they feel like they have a strong enough case? A lot of some of the things we've discussed is you have to identify real identifiable people, and how close do you come to actually identifying them versus maybe what you said actually technically could mean this person, it could mean that person. And so like, there's going to be like legal defenses, I'm sure, that, you know, if Candace Owens isn't naming people exactly by certain names, like, oh, this particular staff member was involved in this particular way, I think she might have some wiggle room, at least to potentially, you know, avoid a civil litigation suit, only because maybe the plaintiff just feels like, man, this is going to be really tough to prove and really expensive to prove too, if, you know, if you bring it. And then also, you know, some of those like TPUSA and Erica Kirk, like they're public, you know, figures at that sense. So it's like, if their defamation suit is not successful, you know, and then let's say Candace Owens herself, you know, brings that anti-SLAPP suit against it and says, I'm trying to participate in matters of public opinion and public concern and stuff, then, you know, Erica Kirk's attorneys could potentially face, you know, and Erica Kirk herself could face like attorney's fees if they lose that anti-SLAPP motion. So it's, or even the TPUSA or others. So it's just like, you have to calculate like, how strong is our case? If we lose, we might face attorney's fees because we're dealing with matters of public opinion. And so it's a tough situation to be in for the parties.
Yeah, absolutely. There's an example, and I think this will be my last question, and any questions from the audience as well. So we don't have Nick sitting here all day, 6 hours, because I can go 6 hours. But I want to ask about Tim Pool. He's another content creator in particular where in that situation, Candace Owens brings him up, you know, because he gave his criticism of her. Candace, in her mind, in her alternate reality, doesn't believe that people have the right to free speech when it comes to criticizing her. But when he criticized her, of course, she, you know, said something back. And then what resulted from that a couple of days later, ironically, and I can say that ironically, his house was shot at. And so there's a lot of questions being, you know, thrown out there as to whether or not that was done simply because Candace Owens brought him up. If he decided to file a lawsuit, you know, and he says, well, hey, this incident occurred 2 days after I said something about Candace Owens, and she responded back to me, and she called me a bunch of names and said all these things, but now I have to deal with someone shooting at my house. What do you think, or what are your thoughts on that if he decided to sue and say she's involved?
So the only way that he could possibly recover in a situation like that against Candace is he would have to show that there's like an agency relationship between the shooter and Candace Owens, and that Candace Owens directed that, you know, because Candace Owens isn't responsible for the conduct of others, you know, too. She can say certain things, and if people interpret that a certain way and they act, you know, in a criminal way after that, based on what they heard, you know, unless it's like a, you know, you can't call for violence and stuff and direct it at people. That would be a violation of the First Amendment as well. Like, that's not protected by the First Amendment. So, yeah, it's just, if what she's saying just makes people kind of hateful and they're willing to act in a criminal way of hate, you got to hold accountable the individuals that actually committed the act, not just Candace Owens for stating things. It's just, I guess, with Tim Pool, I don't know if you saw my post. So Tim Pool is definitely Tim Pool, like, what's interesting is when I was in law school at Rutgers, there was this judge that I knew who, you know, I saw her speak once or twice. I never really had a relationship with her. Some of my classmates said that they really liked working with her and stuff, but she had a couple countrovers cases, because when you're a federal court judge, like, some of the cases that come across your desk are cases you're going to see in the news and stuff. So, so she had a case involving a men's rights attorney here, or there was a men's rights attorney in California who he went crazy, and he drove all the way to New Jersey because he wasn't doing well in the case that he had with her, and he targeted her and her family and shot and killed her son, and then shot her husband, and then like he survived. And then she like went on the news and gave like, you know, she was almost like, we need to be more protected as federal judges because our public information sometimes out there, and pay crazy people look it up and target us. And so she was trying to push for litigation in that aspect to protect, you know, herself, and try to use her example as like a way to do that. And I felt bad for her, but then like literally within like 24 to 48 hours, Tim Pool picked up on the fact that she was overhearing something to do with an Epstein case. And so he correlated hit that man who had another case with the men's rights stuff with Epstein. He started talking about, was she targeted because of the Epstein stuff? And it was like, when you see, like, because I was actually classmates with her niece, and her niece was a very, nice young woman. And I never really had much of a friendly relationship with her. I kind of saw her around the building. And like, I don't know, when you kind of see people like that and you interact with them, and then like, some tragic events like that happen and people start piling on, it just kind of teaches you that, like, whenever there's gaps in information, people are going to fill them. And all it took was seeing a judge targeted, seeing a case on her docket that so happened to be, Epstein related in some sense. And that was enough for people to connect the dots on that. But it was really a matter of this one attorney just didn't like how she was dealing with the case. And, she refused to hear like an oral argument from him and stuff like that, because she was going to decide the motion on the papers. And like, I don't know, that attorney, he had like some Russian wife who left him, and then he went crazy as a result and blamed the court system. And, it's
oh my goodness,
psychotic.
You can make this up.
Yeah.
Wow. So, that, I'm sorry, I'm let you finish.
No, I was just going to say too, like that same attorney, he kind of, offed himself after that, after he did those crimes. Yeah. So he never faced accountability for doing that. Actually, he disguised himself as a FedEx driver to approach the home too. And so it was a terrible situation, but he had brought some cases where it was like he was challenging local bars under gender rules, because you can't gender discriminate, but he would challenge bars for having like ladies' nights. And he would say that's a form of gender discrimination. So he had this like personal kind of vendetta, you know what I mean, to get after like certain women, I think, that he thought affected his lives very negatively, whether it was his wife or the judge, dealing with this case. So
wow, that is, and you know what, and that leads to Candace making this statement, which is it was so disgusting. She stated in the show, because she has an issue with Ukrainians, I guess. Who knows what the background is on that? But she actually stated that if anyone lives in certain areas in the state of Tennessee, that if they believe that these people are Ukrainians, that they are to contact the local authorities. And that was it. And it was like, okay, but based on what crime? You have to be committing a crime. You're directing people to contact the local authorities. If you believe that these people if they look like they're Ukrainian, or how would they know that? Who knows? But if they're Ukrainians, contact the local authorities, because I don't believe that they should be here. You're telling people to contact. That is a crime, to file false police reports. Here's an example of where she's directing people to do things that go against the law. And then you're saying, contact the local authorities and say, well, here's some Ukrainians here. Ukrainians here in the state of Tennessee, but what crime are they committing? You're literally putting people out there, in danger. Like, you're endangering people's lives and their safety, disrupting their quality of life, the right to live in peace. When she's doing these things, it's kind of hard to say she's not. And she said other things in the past to where, people are getting this incitement to want to, send death threats. 2 men are in jail because they were influenced by Candace Owens. And they sent online death threats to Jewish conservatives that she targeted. So, when you have those examples of her having that influence, where people are incited to violence, or she's directing them to contact the authorities because they might possibly be Ukrainians. How would they prove that? Who knows? But when you have those situations lined up, wouldn't that be viable? If someone decided to file a lawsuit to say, here are some other examples where she's doing this. This is a pattern of behavior. Harassment is, showing a repeated pattern of behavior. Wouldn't that hold up, as at least something viable if someone like Tim Pool, for example, decided to file a lawsuit after having his home shot at?
I would say
your thoughts on it.
I would say no, only because it's difficult to prove causation. You have to show that Candace's acts caused these, this result. And I think what her defense would be is, my acts didn't cause that result. This person did that themselves. And they're their own person. I'm my own person. And that would kind of be the framing of it. So it would be a ultimately a causation analysis on who caused the negative result that occurred. And I think she would have strong arguments in that, because generally, you know, it's different than directing a mob like, hey, go attack this person because they did this, versus like, you know, if you're just like, I don't like X group because I find them despicable for Y reason. If that just gins up hate, you know, what I would recommend is you just have different voices that can kind of reason with people that become, you know, hateful. But yeah, she wouldn't be held accountable just for hateful acts of others. You know.
Okay. Or what about the her statement saying to contact the authorities if you see Ukrainians in Tennessee? I mean, what these poor people, if they got the authorities calling them, you're talking about, you know, quite possibly them having to interact with police for no reason. I mean, what would be her liability in that?
Yeah,
She's directly saying to do that.
yeah, so it's definitely, it's not directing violence, I'll say. If you're just directing people to call the police, she might be legally, you know, incorrect on, you know, like the standards to call. It's tough. I've never heard of a case like that, truthfully, like somebody getting, you know, like doing that. So I'd have to do some research on that. My instinct though is like, ultimately you're generally responsible for your own acts. But I mean, here we're dealing with like, if the police suddenly got a bunch of like administrative calls that they've got to sort through, like what's the quantity? Is it only like 1 or 2 calls as a result of this, or is it 10,000? So it's like, I think you would have to take into that. And then, you know, maybe it's tough. I'd have to consider that more.
Okay. This is what I love about you, Nick. You give us the matter of the fact, direct answers and responses that we all need to know. And you're very impartial. And I appreciate that. If you guys have any questions that I did not get to here, let's see here. The Tucker speech. Okay, I'm sorry. That's not for me. If you have any questions that you would like for me to send over to Nick Brooks, please make sure you email me at ladyluckclubllc@yahoo.com. Make sure you go check out his channel. And he does look at his comments. So yay. You guys can also ask questions directly under his videos. But this has been fantastic. And I enjoyed Jay Wick coming up. He had to step out, you guys. So he dropped off. But I appreciate you so much for coming in. I have definitely enjoyed this. They say you are the bomb, honey.
Hey, thanks a lot.
He's well dressed, well spoken, but I just love your, you know, matter of fact, you know, direct, you know, responses and information. And like I said, the impartiality to me is the best. It just ensures people that we want to put out the facts here in the Lady Luck Club, and we want, you know, I can give my personal opinions of Candace all day, and I will this evening. But when it comes to the facts, I mean, especially dealing with legal matters, you want to have someone that is knowledgeable of the law and that's going to litigate matters in the right way based on court rules and the evidence, and stick to the facts. And that is exactly what Nick Brooks has done in this, you know, 2 hours and 43 minutes of time we've had with him. So I want to thank you for your time, and you are always welcome to come back. Maybe we can do a reaction to one of Candace's shows. If you can, I can't watch it by myself. I have to have the Luxes with me. So if you're able to do that at some point, you know, next week is Christmas, but whenever you have free time, you want to do a reaction with me, I would love for that, for you to join us here. That would be a ton of fun. So thank you so much, Nick. You have any other, you know, thoughts, comments, questions, anything you want to share with us before we end?
Yeah, I guess the only thing I would say is thanks for having me. You know, I've definitely followed your show, and like when I first came across your channel, you know, featuring my videos, I was laughing because that was the one I said, well, bring it on, sweetheart. And you were like, oh, but game on, heifer. And I was laughing when I heard that. I was like, man, that was one of the best YouTube videos I've heard in a while.
Oh, thank you.
Yeah. But other than that, no, I mean, I just appreciate you, like a lot of the commentary. I think it's important that like people publicly dialogue about these issues. I think you and Jay Witt do a great job, like, you know, dialoguing about them in good faith. You try to, you know, keep the evidentiary standards high, and you know, you do good faith questioning, and like ultimately a lot of truth lies in the adversarial process. So like, you know, the different points going back and forth, and like trying to get, you know, expert opinion or get knowledge of the different documents. Like, I think that's important. Your followers definitely love it. And, I appreciate you supporting my channel, and like your followers definitely support it as well. So, I'm grateful for that.
Thank you so much. I appreciate that as a compliment. And I'm going to be doing a marathon at I think it's set up for 5 or 6. I think I can't even remember the time I have it set up. I think it's for 6 p.m. Is it 6 p.m. this afternoon? I'm going to be doing a marathon on her 3 episodes. So that's going to be fun. And then it's 5 p.m. Eastern Standard Time. So within the next hour and a half, I will be doing all 3 of her most recent episodes, plus taking a look at her interview with Piers Morgan. I don't know if you've seen that, but I've seen parts of it. And oh my goodness, he's asking direct questions. I mean, he's been doing this for a long time. Piers Morgan, I think, asked questions that needed to be asked about, especially her, accusations and inference of TPUSA being involved in the cover up of or associated or affiliated with the murder of Charlie Kirk. So, you know, she had a hard time, of course, answering it. And what she does is overtalk. She just overtalks. She just goes on and on, and she doesn't provide anything of substance. And is that it's not even answering questions. It's not even debate. It's just her rambling for the sake of rambling, and it is something else. So if you're able to tune in, join us. And if you want to come up during the marathon at any point in time and give any thoughts or insight, please do so. But I do appreciate you tuning in. You guys, thank Nick Brooks for coming in. Make sure you guys go check out his YouTube. And I'm going to end it out. So I'll drop you, but you let me know if you have any other questions or any availability you have to do a joint reaction. That would be a lot of fun. And I think Jay Witt is looking forward to speaking with you as well.
Wonderful.
And I'll be tuning in with that.
All right. Well, hey, no, have a good day. It was good to speak with you.
You too. Thank you so much. Have a good one.
Bye.
All right. Bye-bye. Y'all, Nick Brooks, I am so happy. Oh, thank you all so much for tuning in. That was so much fun. I've been looking forward to that. I hate that I had technical issues, but if you guys are just coming in, please make sure you check out the replay. We addressed a lot of information, answered a lot of your questions, and he did exactly what I am so glad he did, and I was hoping that he would do, and this to give direct information, direct facts. That way, because Candace, I know you listen to Heifer. You can't say, oh, well, she told him to say this and that. Nope. Even when he gave a response that was, well, no, maybe she would now be able to prove this, prove that. We give the facts here, and we want it to be as neutral and just as direct and straightforward. And I appreciate all of you all so much for tuning in. Let's get Nicholas' YouTube channel link dropped once again. How you doing, Billy? And then I'm going to get to some supers. I appreciate you guys so much. We're going to be back at 5 p.m. for all of her episodes. We gotta do 3. So you guys need to come prepared with lots of Kool-Aid and popcorn. Great soda. Get your gummy worms. Have a meal. Bowl of ice cream, something. And we're gonna have at least 3 hours dedicated to that, because I want to cover her last 3 episodes she's done on Wednesday, Thursday, and on yesterday. And of course, the Piers Morgan interview, along with a couple of other videos that you guys sent me that just, we need to watch. But I enjoyed this. You guys, this is what it's all about. Being able to ask questions and get real information that can also be researched. The aspects of, the law and what from state law to federal law would permit, court rules, those things are a matter of facts that can be researched online, that you can read about. And that's what I, appreciate the most. And I am so excited for Nick Brooks and his success with his channel, as well as the success of the Lady Luck Club. If you are not subscribed, subscribe. We're almost at 30,000 supporters. And I want to see that number hit hopefully by tomorrow. I mean, when I say we're close, we're so close. I'm less than 31 people away. I am 31 subs away from 30,000. So let's make that happen, you guys. Hit that subscribe button. And if you want to become a member of the LLC, consider becoming a member. I appreciate all of the support from you all. I'm going to get to supers here And make sure you guys check out from the beginning. We discussed the Macron lawsuit. We talked about the Tyler Robinson ordeal, and of course the standing order with the decorum. Nick said flat out, "I would have had them sanctioned." If you're gonna have media in the courtroom, they're gonna have to follow the standing order. He would have sought sanctions because it could create another level of bias towards the case. You're giving the defense more viable arguments for an appeal. All these things simply because someone felt that, well, the public needs to know that. No, we don't. It's called doing things in decency and in order. We have laws for that. We have court rules for that. And standing orders are as good as law. And so follow the order. It's that simple. And this media group, it's a conglomerate of different medias that have come together and were given permission to record the murder trial and be in the courtroom. They need to handle that responsibly, because listening to all these, clowns out here that didn't go to law school tell you, well, we have the right to know everything. No, you don't. But they don't have anything to do with the hearings either. They're not attorneys. They don't know the law. They don't care about the law. Candace thinks she's above the rule of law. They don't care about court rules. They don't care about, procedure. They don't care about any of that. And when you're invoking more chaos and confusion than clarification, facts, and evidence, these people that are going in and recording as a part of that media group, they need to think about that. They need to think about the fact you could be sanctioned. So, it's a deterrent. It keeps people from doing it again. Let's deter the horrible, bad behavior. Let's get off these high horses and stop thinking that, someone owes you something. That's not how it works. And so we want the bad guy off the street. We want him to get a hearing so that if he is indicted and found guilty, it makes it harder for him to come back and try to appeal it, because members of the press were just recording things that shouldn't have been recorded, and it was streamed to, the public. It's unnecessary. Let the matter proceed through the court the right way. And then once it's done, whatever information the court is willing to release to the public will be released. I'm sure there's going to be a demand for it, but it's all about timing. So I appreciate you guys. Let's get the supers in from Jay Witt. Thank you for the $10 super. Y'all said he would give me a $50 super once we hit 50,000 subs. I'm looking forward to that. So make sure you guys are subscribing. Share the content. Subscribe. Tell everybody about it. If your friends, your cousins, holidays is coming up. Say, hey, you guys, make sure you go on YouTube and check out the Lady Luck Club. She's funny. And we enjoy her content. And I always want to, bring forth facts and the evidence here. We're going to be going over another lawsuit too. Shout out to those who were sending me emails. You guys, just let me know if you want me to. I know S-Files doesn't mind. For all the information you guys sent to me, I do verify and vet. So if I move slowly on something you've sent me, it's because I have to verify this information and corroborate it with something in my research, because that's the proper way to do it. But there is a lawsuit that was sent to me. Candace, we're going over that lawsuit, girl. Dealing with some sort of a coin, like Bitcoin, but it was a pump and dump scheme, which is fun for me. I love those. So we're going to be going over that lawsuit at 5 in our marathon. I can't wait. So let's get these supers in so you guys can get off and go eat some food and then come back at 5 p.m. And then, of course, let's see. What's the super? I was trying to pin up questions as well. Heather Rose, thank you so much for the $4.99 super. I appreciate it. A lot of these questions that were asked, Nick did address and answer the questions. Care Bear sent a $4.99 super. Thank you so much. Heather Rose sent another $4.99 super. I hope the Macrons press for a jury trial. There is a jury demand, so they will have a jury trial if it proceeds to a trial. There is a jury demand, and there will be a jury trial. I just want to be one of those press members so I can record. I don't know, or just at least be able to, be able to record it and then just kind of share the information or live stream it out. I would have to get permission from the chief judge of that court. So I'll work on a request to the court and see if I can get permission to record the hearing virtually at the least bit. start there. So, and see how it goes. Yay. Thank you, Wyoming Gas. Shout out to my mods, you all. Thank all the mods as well for holding it down in the chat, both in the standard broad as well as the vertical broad streams. I appreciate you guys, the broadcast. Thank you so much for holding it down and for being on hands on deck. Jay Witt is also a mod here too, so I appreciate him coming in and helping to mod as well. Wyoming Gal sent the $10 super. This seems like a public perception case. The Macron should just produce a statement from her doctor and a picture of her and her brother together as adults or appear together in public. Yeah, and I think they have several photos that they've submitted over to Candace where they were trying to get her to correct the record, and she just kind of dismissed it like she does anything else. And so now it's going to come down to it being admitted as evidence in the case. And it's going to be through testimony, which is also evidence. Candace, you got to come, girl. She's going to lose. She's going to lose. But, if they bring in scientific evidence to support that, that is going to be sufficient to prove that she was indeed born a woman. It's just going to, shatter anything as far as the defamatory statements made. Candace did purport that to be a fact, and that's what messed her up. She can't say, well, that was my opinion. No, she actually, out of her mouth, said it is a fact that Brigitte Macron was born a man. She said that. That's exactly what she said in an episode a few times. So it's in videos. So she can't go to court and saying, well, Your Honor, I was just giving my opinion and da. No, she said it is a fact. And once she said that, I keep telling you, heifer, that's where you messed up. You messed up when you said it is a fact. So purporting something that you have no evidence to prove to be a fact is where now you've gone into the realm of being defamatory. And then to be malicious and have this reckless disregard for the truth after they sent you all this stuff and you still want to ignore it. You're going to lose. Now you're trying to insinuate they're involved in somebody's murder in a civilian in a country they don't even reside in. It's insane. So thank you so much, Wyoming Gal. I appreciate that. Let's see here. MT, thank you for the 199 super. Our Faye Facts first stoic lawyer is a guest. Nick Brooks is so adorable. He's so sweet. But he has a very candid way of answering questions. And if he doesn't know, he said, I'll have to look into that. I'll have to research that. It's something else that I can appreciate. If you don't know, take time to research and read. And of course, you expect good attorneys to be able to do that. And I appreciate him and his candid responses. So let's see here. Let's get to Heather Rose, another 49 super. Thank you so much for that. Candace repeatedly says things like, I know for a fact when stating her claims. Yes. And for her flat out to say it is a fact. There's no other way to draw a conclusion when you're saying it is a fact. There's nothing else anyone can get out of that other than them being under the belief after you stated that and you delivering that, saying that she said this is a fact. It is a fact. There's no confusion in that. So the average person would say she stated this as a fact. Candace. And she runs off when she's mad. Like you have no control, you're no poise, no tact, no nothing. Even when I get frustrated, I still don't sit here and say it is a fact and blah, blah, blah. And then I can't prove it. It's not how that works, Candace. Go to court, girl. All right. So let's see here. I want to make sure I get. I want to thank you all so much. Now, I think this super was for Jay Witt podcast. MT, yours was okay. Yours was there for. Oh God, why didn't I notice this at the top? Okay, so this MT and J, Captain Jax is for Jay Witt, but I'm able to see them all because my live stream is the host live stream, and you have some YouTube channel link for Nick Brooks, so make sure you guys go check him out. That's a new member, I think, for Jay Witt. Thank you so much, Captain Jax, for posting up my YouTube channel, link over there on Jay Witt's live stream. He's still streaming. Let's see here. Blue Moon sent over a 999 super to Jay Witt. Nick is a legend in the making. Thank you. And then another 999. Cult leader found responsible in the past for violence other committed. Bullying and lying as well. She is a bully and a cult leader. In my opinion, Candace is definitely a cult leader. Her cult of personality is extraordinarily dangerous. And because, many of her followers are, all of this is virtual, right? It's all over social media. You can't see most of these people's faces. So you don't know who they really are. And that's what makes it even more dangerous. They go after, they can have 20 profiles and you have no way of knowing. That's what makes them very dangerous. Telling people to call the authorities because you're looking at what might be perceived to be a Ukrainian is absolutely reckless. It's reckless. You're inundating, the local authorities, their phone lines, time, resources. They're going out thinking something has happened. And it's all because some person thinks this person is Ukrainian and they don't belong in the state of Tennessee because Candace Owens said so. The stupidity of it all. It's insane. So, yes, that cult of personality is real. We've gone over that information. Paramount Tactical also covered that with a special guest. I can't remember her name, but they did a great job at it. And we actually reacted to that video. We showed it here in the LOC so that you guys can see that this is why I'm covering, various cult leaders. We talk about Eligio Bishop, also known as Nature Boy and Carbonation. We're focusing on the new series from Hood Horrors with Polite. Those people are connected to cults, or they were cult leaders. And they admitted it. They were cult leaders. So you get this real-time example of these cults. And what we're seeing is this cult of personality uprising, in slow form on social media with Candace Owens. And then for everyone to be perceived the enemy because you give criticism. She doesn't like free speech when it's directed at her. But when she says something stupid, or derogatory or defamatory, oh, she's exercising free speech. That's mentality that you expect from a cult, where you can't say anything about their dear leader. How dare you? But then that dear leader gets to say whatever they want to say about everyone else. And then try to curtail, responsibility. Nope. So the Macrones are showing us how it's done. No, man. Thank you so much for the comment, though. I appreciate that. Laura, shout out to my mod. She's also my administrator here in StreamYard. So thank you so much for the $5 super. Thank you, Nick, for coming on. I hope you guys enjoyed this. This was informative. This was the opportunity to ask several questions to a well-informed attorney who is very knowledgeable and educated. Listening to anyone outside of someone who has an understanding of the law, I don't do it. When people are saying we have the right to know everything, yeah, okay, name that right. Yeah, name that right. What's going on, Proud Liberal to you? So you guys make sure you tune in at 5. Thank you so much for you guys' support and for checking out Nick Brooks, his channel. We showed a couple videos today that he was able to help us through. You guys make sure you tune in. Within the next hour and 15 good minutes, we will be back. So thank you so much. Hit the like button on the way out. Subscribe. We're almost there at 30,000. Let's get to that one. And until the next one, Lady Luck Club out. Deuces.